I'd like to call the roll before we go on with the agenda. Sharice, are you here?
I am and ready to go.
Okay.
Dr. Raggio,
Here?
Ms. Kaiser,
Here.
Mr. Borges, Ms. Chang,
Here.
Ms. Dominguez, Ms. Dominguez. We'll circle back. Ms. Snow,
Here.
Dr. White,
Here.
and Ms. Dominguez.
We hold on for a minute and wait for her to join.
Well, let me also check the attendee list. Because it looks like she may have had to log out. I don't see her on the.
Oh, yeah, I don't see her either.
I want to wait just a few minutes.
Maybe Holly's able to text her.
I believe we just got Miss Dominguez.
Oh, good. Oh, yeah, I see her. Yeah.
Yes, can you hear me? Sorry, I was having technical difficulties, so now I'm on my phone.
You're coming in loud and clear.
Thank you.
All right, we are all back, Dr. Raggio.
Okay, thank you. So I'd like to move on to item 9, update and discussion regarding the board's 2022 sunset review and the board sunset bill, which is Assembly Bill AB 2686. And I believe Paul was going to give us that update.
Yes, good afternoon and welcome back, everyone. I'm going to go ahead and provide just a little bit of background for the sake of those that are in attendance and just kind of go through the sunset bill. I would also encourage you to ask any questions that you might have throughout this process, and I'll try to keep track of your hands being raised, and we'll try to answer them as we go along, because I think it's real important that everyone understand what's in this sunset bill and what we're doing through this process. So as you know, the Assembly Business and Professions Committee and Senate Business Professions and Economic Development Committee hold a joint committee that they refer to as a Sunset Review Oversight Committee, and they hold oversight hearings. This past year was our turn to go through this process again, and it's a joint effort from all of our staff and board members together. We turned in our report back in at the beginning of, or the end of 2021, and we started going through the process in 2022. On March 22, we started working with the committee on the background paper, and on March 10th, we participated in hearings with the board chair and the board vice chair. Following the oversight hearings, the executive officer, the AEO, Sharice and I began to meet with the committee to address issues raised by the background paper and the issues that the committee had, and also we started discussing the issues that we presented. At the last board meeting, I reported that all of the items that we requested to our Practice Act had not yet been obtained. Since that time, we've continued to work with committee staff to obtain as much of the changes as possible. It has been a positive outcome for us. We're pleased to report that most of the items that we requested have been granted. Some of them are in the draft language, and some of the changes are going to be made on the floor later on in the process. But I wanted to go over the bulleted items. So if you look at the memo on the sunset review, it's on page 2. And I also want to report that we've had actually committee hearings. So we've gone through the whole process and we've been able to attend these meetings in person for the first time. So Sharice and I both attended these legislative hearings, waited throughout the day for our bills to be here to show our support. And we also got support from several of the professional organizations that work with us and other stakeholders. So I wanted to go over the bulleted items. And the first item, and the most important item, is that this AB 2686 would extend the board's authority to regulate the professions of speech language pathology, audiology, and hearing aid dispensing through January 1, 2021. That's the purpose of the sunset bill, and that's what we're looking for. Secondly, one of the proposals we made was that the audiology aid registrations, that the speech language pathology and audiology aid registrations expire every 2 years, and that it would require the supervisor of the aid to update the board on the duties the aid performs while assisting the supervisor in the practice of speech language pathology or audiology, and the training program and assessment methods the supervisor is utilizing to ensure the aid's continued competency. This is a slight change from what we originally requested, but we are satisfied with this process because this will allow us to better track who's out there working as an aide and to ensure that they are getting the training that we need. And will also kind of align itself with some of the work that we're doing in looking at the aid designations. The other part of that is that we updated the definition of an audiology aid to conform with the definition of a speech language pathology aid so that it's clear that there are limitations on what they can do and that they're working directly under the supervision of an audiologist. There was some misleading language there that implied that they could practice audiology. And while they're working under the audiologist, they're not practicing as an audiologist independently or performing functions that an audiologist can only perform. At any time, if you have any questions, please feel free to ask. The fourth bullet is requires applicants, licensees, and registrations to provide the board with their email address no later than July 1, 2023, and update the board within 30 calendar days of a change to the email address. And it requires the board to keep email addresses confidential and not disclose this information publicly. This is also going to help us in just keeping track of our licensees for the purposes of communication. And we found that this was problematic during the COVID-19 outbreak and just communicating some of the changes. We did our best to communicate the changes, but it would have been nice to have had an email address for everyone. So that's something that in the future will not be an issue to us. The next bullet removes the statutory requirement for the board to have a hearing aid dispensing committee with specified members and the mandated purpose. This simply gives back the authority of the board to determine the name, composition, and purpose of all of its committees. So, as you all know, there was a legislative mandate that designated the hearing aid dispensing committee and the members of the committee. We have a 9-member board, and most of the board members were on the committee. So we were starting to run into quorum issues in just being able to have a committee meeting for the purposes of making a recommendation to the board. As we discussed with the committee, there's not a whole lot of difference in this committee and the work that they do and the work that the other practice committees do. So whether or not this was mandated in statute, the board would likely continue to have a practice committee for hearing aid dispensers and even look at hearing aid dispensing as a whole. So that's one of the changes that we expect to be made on the floor. The next bulleted item authorizes appointing authorities to remove a board member at any time. And as you know, the appointing authorities are the governor, the Senate rules, and the Assembly, the Speaker of the House. Are there any questions so far on any of the changes that we've discussed? The next item removes a restriction that the required supervised professional experience for licensure as an audiologist follow the completion of the didactic and clinical rotations of the audiology doctoral program. This will allow audiology students to apply for their required professional experience temporary license sooner than it's currently allowed. And again, this is one of those that we didn't get everything that we requested, but this does remove one major obstacle to those trying to get their required supervised professional experience. This is something that the Audiology Committee is currently discussing in relation to the regulations related to these requirements. The next bulleted item reauthorizes the American Speech Language Hearing Association Certificate of Clinical Competence in Audiology to deem an individual to have met the educational and experience requirements for licensure, and authorizes the American Board of Audiology certificate issued by the American Academy of Audiology to deem the same. This will streamline the licensure process for audiologists licensed in another state or territory. Now, just a reminder, prior to the audiology licensing requirements becoming a doctoral degree, audiologists were able to use their 3 Cs, the ASHA 3 Cs, to have met the educational experience requirements. So what we did here is we just updated it to include those that also have their doctoral degree or the requirements in Business Professions Code that requests that. We also pointed out to the committee that the requirements for the AAA ABA certificate are similar and should also be included in that provision of the law. The next item adds the following unprofessional conduct activities to the statute that allows the board to deny a license to an applicant or suspend or revoke or impose terms and conditions upon a licensee. And those are engaging in any act in violation of Business and Professions Code Section 650, which prohibits licensees from offering or receiving consideration in exchange for patient referrals, disciplinary action taken by another public agency in any state or territory for any act substantially related to the practice of speech language pathology, audiology, or hearing aid dispensing. It includes aiding and abetting any person to engage in the unlicensed practice of speech language pathology, audiology, or hearing aid dispensing, and violating or attempting to violate directly or indirectly any provisions in the Practice Act. So these are codes that will help the board if the board is considering discipline or taking action against a licensee for unprofessional conduct. The next bulleted item requires a specified period of time to elapse before a person whose license has been revoked or suspended or placed on probation before they can petition the board for reinstatement or modification of penalties. It also specifies under what circumstance a petition will not be considered and when the board may deny a petition without hearing argument. So without hearing or argument. And the purpose of this is so that if you make a decision to revoke someone's license or administer discipline, you don't have that person turning around and coming back and petitioning the board even before a year has elapsed. So we have actually gotten those kinds of applications. So this actually just puts some parameters and limitations on that. And then finally, the bill provides technical cleanup to the board's Practice Act by updating various sections to include references to BPC section 2532.25, and that's the section, the updated audiology licensing requirements that are post-doctoral degree requirements, removing non-operative statutory provisions in gendered language, and makes other technical changes. So this has been approved by both houses. After this has been approved, by both houses of the legislature and signed by the governor, the board's new sunset date and changes to the practice act will go into effect. Again, as I said earlier, not all the changes are reflected in the text that is included in your board materials, and some of those changes are still to be made. I do want to express my appreciation to the committee staff that have been working with us. Our two consultants have been very cooperative and have engaged and have really learned the business of speech language pathology, audiology, and hearing aid dispensing. So thank you. At this time, if there are no other questions, Dr. Raggio, I'm going to pass it back over to you.
Okay, are there any questions or discussion items the board would like to make at this point? Seeing none, I'd like to open up for public comment.
We are now open for public comment on agenda item 9. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the agenda?
Yes, please. So thank you, Paul. That was really interesting. I'm sincerely happy that we're going to stay alive for a few more years as a board. And thank all the work of Paul, Charisse, and the staff, as well as Holly, to get the sunset bill written and passed. I'd like to now move on to agenda item number 10, legislative report, update, review, and possible action on proposed legislation. I believe Heather Oliveros is going to lead this discussion.
Good afternoon, everyone. Heather Olivares, Legislation and Regulation Analyst for the board. In your materials, I included a memo of an update on the legislation we are currently tracking. And since the time of the memo, there's also was a major deadline. So I have some updates from the information in the memo. So the legislative calendar and deadlines, today is the last day for fiscal committees to hear bills. They actually heard everything yesterday. So I have updates from the outcome of those committee hearings. And then August 25th is the last day to amend bills. And August 31st will be the last day for each house to pass bills, and that will end the legislative session for this year. And then the governor has until September 30th to sign and veto any bills that make it to his desk. So the bills the board has an active position on currently, AB 225, the board currently has an oppose unless amended position. However, this bill is dead. It was not scheduled in the Senate Business Professions and Economic Development Committee. This bill would have expanded current law requiring a temporary license for applicants currently licensed in another state who are married to or in a domestic partnership with an active duty member of the military currently stationed in California to also apply to applicants who are veterans within 60 months of separation and active duty members with official separation orders within 90 days. The concern the board had was it would have removed current provisions that allow a temporary license to expire upon the denial of an application for a permanent license. The next bill is AB 1662, and that is regarding licensing boards disqualification from licensure for criminal convictions. This bill died yesterday. It was held on suspense file in the Senate Appropriations Committee. The board did have an opposed position. This bill would have required boards to establish a process for prospective applicants to request a pre-application determination whether they may be disqualified from licensure based on their criminal history. The board may require prospective applicants to furnish fingerprints to conduct a criminal history record check, and the board must notify the prospective applicant in writing if their criminal history could be cause for denial, and include information regarding the criteria for substantially related crimes, the process to request a copy of the complete conviction history, notification of the right to appeal the board's decision, and the rehabilitation criteria established by the board. This bill would authorize the board to charge a fee up to $50 for this pre-application determination. And the board was opposed to this bill based on the increase in the workload and the costs that would not be covered by just the $50 fee. The next bill is AB 1733 regarding open meetings. Unfortunately, this bill died. It was not scheduled in the Assembly Governmental Organization Committee. The board had a support position. This bill would have required open meetings to provide members of the public with a physical location to hear, observe, and address the state body, and means to remotely hear or hear and observe the meeting and remotely address the state body without requiring public comments to be submitted prior to the meeting. This bill would allow board members to remotely participate in an open meeting without disclosing the remote location. The board would be required to end or adjourn the meeting if the means of remote participation fails during the meeting and cannot be restored. The next bill, AB 2686, is the board's sunset bill that the executive officer just went into a lot of detail. So I will just only provide an update that the bill passed out of the Appropriations Committee yesterday and will be moving to the Senate floor. The board has a support position, so once it reaches the governor's office, we will be submitting a letter to request that he signs this bill. The next
Heather,
bill, yes.
Heather, this is Paul. Can you just hold off one moment? I think we want to pause right here. Dr. Rajo, did you want to pause right here?
Yes, I think this might be a good point. I need to ask for board discussion on the bills that have been covered so far. So let me do that first. So that is 225 through 2686. Bills 1 through 4 on our page, our agenda. Seeing no board questions or discussion items, I'd like to open it for public comment on those 4 bills.
We are now open for public comment on those 4 bills. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the agenda?
Yes, please. Heather, some of the bills that you'll be discussing are going to require a roll call vote. So I believe we're going to have to go bill by bill to make sure that we can get that accomplished at the right time. So, and the next bill is one of those. So if you'd like to continue with that one.
Yes. AB 2806 is Child Care and Developmental Services Preschool Expulsion and Suspension Mental Health Services Reimbursement Rates. This bill passed out of the Appropriations Committee yesterday and will be moving to the Senate floor. The board currently has an oppose unless amended position. because initially the bill had a provision that would have authorized a person with a master's degree in speech and language pathology to receive reimbursement for early childhood mental health consultation services. The board was concerned that nothing in the bill required this person to be licensed, and also that mental health services are not within the scope of practice for speech language pathology. Board staff worked with the author's office to address this concern, and we have since been amended out of the bill. So at this time, I would like a motion to remove our opposition. And I'm not proposing adopting a new position, just to remove our opposition.
Okay, is there any board discussion regarding the bill or the motion? Seeing none, can I have a motion to remove our opposition to this bill?
I motion.
Okay, thank you. Do we have a second?
I second.
I would like to, if there's no further discussion, open for public comment at this time.
We are now open for public comment on the motion. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the motion?
Yes, please. If there's no further discussion by the board, I'd like to call for the vote. If Sharice would assist us.
Absolutely. Dr. Raggio,
Aye.
Ms. Kaiser,
Aye.
Mr. Borges,
Aye.
Ms. Chang,
Aye.
Ms. Dominguez,
Aye.
Ms. Snow,
Aye.
Dr. White.
Aye.
Motion carried.
Okay, Heather, if we could also approach the next few one by one.
Okay. SB 1031 regarding healing arts boards and an inactive license fee. This bill is dead. It was held under submission in the Senate Appropriations Committee. The board currently has an opposed position. This bill would require the renewal fee for an inactive license to be half the amount of the fee for the renewal of an active license unless the board establishes a lower fee. The board was opposed to this bill based on the revenue loss and the blanket establishment of it being half of the cost of the full license without requiring a fee audit or any other kind of evaluation, whether that lower fee is appropriate.
Do you understand or know what the motivation was to lower that to half?
Yes, just because to encourage licensees, for example, when they move to another state, they may not necessarily be using their California license, but to have the ability to still maintain it without having to pay the full cost.
Okay. Is there any other board discussion about this bill? Seeing none, can we open for public comment?
We are now accepting public comment on this bill. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the bills?
Yes, please. Okay, Heather, would you continue, please?
The next bill is SB 1453 regarding speech language pathologists and the fees procedure. The bill is currently on the assembly floor and will be pending additional amendments that I will discuss. The board currently has a support if amended position. This bill would allow a speech language pathologist to perform the fees procedure in primary care and specialty clinics, county medical facilities, hospitals and skilled nursing facilities, hospice facilities, and medical group practices without the presence of a physician, as long as the facility has protocols for emergency medical backup procedures, including a physician or other appropriate medical professional being readily available. This bill would also remove the requirement that an ENT authorize the fees procedure and instead allow a speech language pathologist to perform the fees procedure upon the orders of a licensed physician. This bill would prohibit the fees procedure to be performed on patients who have contraindications that would prevent the procedure from being performed safely. Additionally, this bill would clarify that a speech language pathologist must perform 25 supervised fees procedures, including 10 supervised by a physician who performs nasal endoscopy and 15 supervised by an experienced physician or speech language pathologist competent in the fees procedure. The speech language pathologist must obtain written verification from one ENT that they perform the minimum of 25 procedures and are competent to perform the fees procedure. Board staff is recommending at this time we move to a support position after having worked with the author's office and sponsor, which is the California Speech Language Hearing Association, to address the board's concerns. Although emergency medical backup procedures, other medical professional and readily available are not defined in the board's laws and regulations, the bill was amended to limit the settings the fee procedure can be performed to include primary care and specialty clinics, county medical facilities, hospitals and skilled nursing facilities, hospice facilities, and medical group practices. The laws and regulations governing medical backup procedures for these facility types would need to be followed. Additionally, board staff reached an agreement with the author and sponsor to address concerns regarding contraindications to the fees procedure. The bill will be amended soon to include a history of vasovagal episodes and cardiac disorder with acute risk of vasovagal episode and bradycardia to the list of contraindications, and would allow the fees procedure to be performed when contraindications exist if documented clearance from the physician that the fees procedure can be performed safely has been obtained. With the amendments agreed to by the author and sponsor, as well as the much needed clarification to the requirements for the fees procedure, board staff recommend the board adopt a support position on this bill. Included in here is the current languages of the bill, but as I discussed, we are anticipating additional amendments as well. So I'm happy to answer any questions and get a motion to move to support.
Heather, I want to make sure I understand, even though you've read all this, really what are the contraindications, or what circumstances can fees not be performed by a speech pathologist who does not have a physician readily available? If I'm asking that clearly.
So that's two separate issues. The procedure can be done in any of the locations specifically listed in the new language, with as long as they are following the regulations that are established by other entities, specifically Department of Public Health regulates a number of these facilities where the procedure can be performed. So the emergency backup procedures based on the facility, they would have to follow those requirements. So it's not necessarily with a physician available, it's whatever the standards are set by the Department of Public Health, which is regulating the facility. And then the second part of your question for the contraindications, there is a number of them listed currently in the legislation, and that is on the back of page 2 on the back of the language. And so currently the contraindications are bilateral obstruction of nasal passages, refractory epistaxis, facial trauma, recent trauma to the nasal cavity, severe bleeding disorder, severe movement disorder, severe agitation, and inability to cooperate with the examination. Those all came from ASHA as in a document we were looking at on the fees procedure. So we mirrored the language after that. And then we're going to be getting amendments to include the 2 additional ones that I shared. And then part of those amendments is also going to be that just because these conditions exist doesn't mean necessarily the fees procedure can't be performed, but the SLP and the physician making the orders will need to collaborate and determine if the procedure can still be done safely. And then if that's the case, the SLP will have in writing from the physician that they can perform the procedure.
I know that board staff met with Dr. Valdez and
Correct.
Gilda Dominguez.
Correct.
And I know I wish he were on the call today to give his blessing on this, but he isn't. So perhaps I could just call on Paul to, if that's the legitimate thing to do, to assure us that he's on board.
Yes, I would also add that I think Gilda Dominguez is on the call, and she might be able to also, summarize some of our discussions, if she so wishes. Otherwise, I can make some comments.
Yes, we did have, I'll go ahead and speak. Yes, we did have the meeting, and there was a lengthy conversation regarding these contraindications. They are considered relative contraindications, meaning that, that the procedure is acceptable to do so if the benefits outweigh the risks. So we confirmed that, yes, we receive an order. There is a collaboration that does occur between a physician and a speech pathologist for these procedures. And to have that documented for these relative contraindications is protecting the consumer, and it is also allowing speech pathologists to perform this procedure that needs to be done in order to continue with a treatment plan and to progress the patient through rehabilitation, for example. Yes, Dr. Valdez was involved in those conversations and did seem to be on board with this.
I would also like to add that I think since the time that I've been with the board, this has been one of the most frequently asked questions requiring or requesting clarification, because there are a lot of areas that just are not clear. Even when it talks about approving procedures and who is supervising the procedures. Currently, there's a lack of clarity in safe settings and emergency backup procedures, and there are no contraindications listed. So I think we are satisfied with the fact that this does provide more clarification and that we have worked together to identify some consumer protection safety protocols. Thank you.
So are we feeling comfortable that if during a procedure someone undergoes, something untoward, that their public health has a series of steps one takes to ameliorate that, and that we're comfortable with that?
Well, I think the elements of supervision are covered. I think that there are also, in the various settings, there are regulations, there are requirements for safety. So I think you have the oversight. And I also think that we've touched on the training component. So we're also ensuring that the practitioner is trained and that they're getting a specific level of training. So I think we've covered on the three big issues that needed clarification and provide consumer protection.
And I think to confirm as well, the regulatory oversight of these facilities by the Department of Public Health, and then those that aren't by the accreditation bodies for those medical facilities are well established. And I think that's something that we are very comfortable with in those locations.
Okay, Paul, you concur with Gilda that Dr. Valdez is in support?
Yes.
Is there any other board discussion about this? Holly?
Well, I'm really appreciative of the team that worked on this together, board staff, Gilda, Dr. Valdez, Kasia. I really like the training component that Paul just pointed out. The fact that you're really specifying how those 25 supervised hours play out and the final approval sign off by the ENT. I feel like this is a very solid plan.
Okay, thank you. Any other discussion? Seeing none, I'd like to ask for a motion to support this bill.
This is Gilda. I move.
Do we have a second?
This is Holly, I second.
Okay. I'd like to ask the moderator to open for public comment.
We are now open for public comment on the motion. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. And our first request comes from Andrea Ball. Hold on just a moment. We're sending you a request to unmute your microphone.
Good afternoon. Thank you. This is Andrea Ball here on behalf of the California Speech Language Hearing Association, sponsors of the bill. We really appreciate the collaboration and the insights and the input from the board members and the board staff on the bill. The amendments that have been made and the ones described that are forthcoming, we think really do provide added clarity, and that's to the benefit of patients, consumers, more access for them, and training opportunities for speech language pathologists, excuse me, to perform this valuable procedure and the swallowing assessment and treatment. So thank you very much to all of you.
And that was our only request for public comment.
Okay, then let's go back to the board, and if there isn't any further discussion, I'd like to call for the vote.
I do not see any hands raised, so I'll go ahead and call the roll. Dr. Raggio,
Aye.
Ms. Kaiser,
Aye.
Mr. Borges,
Aye.
Ms. Chang,
Aye.
Ms. Dominguez,
Aye.
Ms. Snow,
Aye.
Dr. White.
Aye.
Motion carries.
Okay, Heather, would you like to continue with the bills with recommended watch status?
Sure. And just to clarify, did you want me to go through these one by one like we have been as well?
Oh, I think we're going to do these collectively and then we'll ask for a comment.
Okay, perfect. So the first bill with a recommended watch status is Department AB 646 regarding expunged convictions. This bill actually died yesterday. It was held under submission in the Senate Appropriations Committee. This bill would have required boards that post information about a revoked license due to a criminal conviction on the online license search system to post the expungement order if the person reapplies for licensure or has been relicensed, or remove the information if the person does not reapply for licensure. The board would have been authorized to charge a fee of $25 to cover the costs of administering this provision. The next bill is AB 1308 regarding arrest and conviction record release. This bill is also dead. It was not scheduled in the Senate Public Safety Committee. This bill would have expanded current law regarding arrest and conviction record relief to allow an arrest or conviction that occurred on or after January 1, 1973 to be considered for relief. The next bill is AB 1795 regarding open meetings and remote participation. This bill is dead. The bill was not scheduled in the Assembly Governmental Organization Committee. This bill would have required open meetings to include both in-person and remote participation. This bill would define remote participation as participation at a location other than the physical location designated in the agenda of the meeting via electronic communication. The next bill is AB 2600 regarding state agencies, letters and notices. This bill is dead. It was not scheduled in the Assembly Accountability and Administrative Review Committee. This bill would have required state agencies, when sending any communication to a recipient, to include in bold font at the beginning of the communication whether it requires action or serves as a notice requiring no action. The next bill is AB 2790 regarding reporting of crimes for mandated reporters. This bill died yesterday in the Senate Appropriations Committee, and effective January 1, 2024, this bill would have removed the requirement that healthcare providers report to law enforcement any assaultive or abusive conduct unless the wound or injury is self-inflicted or caused by a firearm. Instead, this bill would have required healthcare providers that know or suspect their patient is experiencing domestic or sexual violence to provide brief counseling, education, or other support, and offer a referral to local and national domestic violence or sexual violence advocacy services. The next one is SB 731, Criminal Records Relief. This bill is currently on the Senate floor waiting for a vote in concurrence in the Assembly amendments. This bill would expand current law regarding automatic arrest record relief to include a person who was arrested on or after January 1, 1973, if criminal proceedings are not initiated within specified timeframes. This bill would also expand automatic conviction relief to include felonies committed after January 1, 2005, if at least 4 years have elapsed since the completion of all terms of incarceration and parole without being convicted of a new felony offense. This provision excludes serious and violent felonies and felonies requiring registration as a sex offender. The next bill is AB 1237 regarding licenses for military service. This bill has passed and will be going to the governor for his signature or veto. And this bill would expand the requirement that boards waive renewal fees and continuing education requirements to include individuals in the California National Guard or United States Armed Forces serving in an active duty status, regardless of the duration of their active duty assignment. The next bill is SB 1365 regarding licensing board procedures. This bill is dead. It was held under submission in the Senate Appropriations Committee. This bill would have required boards to post the criteria used to evaluate applicants with criminal convictions on their website to help inform potential applicants about their possibility of obtaining licensure prior to investing time and resources into education and training. This bill would have also required the Department of Consumer Affairs to develop processes and procedures for boards to use to verify applicant information, perform background checks, and provide an informal appeal process. I'm happy to take any questions.
I have one. Often when you introduce a bill, you'll say to us that it was not scheduled in such and such committee. What does that mean, that it's not scheduled and therefore it's dead?
So there are certain deadlines all throughout the year. And so one of the early deadlines is that a bill needs to be heard in its first policy committee by a certain date. And so if the bill is never scheduled in that committee, which means they didn't even bother to take it up, like the committee decided, or even maybe the author decided not to hear it in its first policy committee, once that deadline hits, it's considered dead because it missed its very first deadline.
Okay, so it sounds volitional that the author or whoever is just letting this happen.
Yeah, a lot of times if the bill's introduced and the author gets a lot of opposition right out the gate, they may decide not to even move the bill forward.
Let's see. Okay, is there any other board discussion on the watch bills? Seeing none, can we open up for public comment on these bills?
We are now open for public comment on the watch bills. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the agenda?
Yes, thank you. So thank you, Heather, for that, the detailed description of all of these bills in both statuses. I'd like to now move to agenda item 11, legislative items for future meeting. And the board may discuss other items of legislation in sufficient detail to determine whether such items should be on a future meeting agenda and or whether to hold a special meeting of the board to discuss such items pursuant to Government Code Section 11125.4. Is there a board staff member who would like to introduce that further? Or can we
This
do
is-
this? Yeah, go
This
ahead.
is Heather Olivares. We put this as a placeholder in case any bills are amended after we've already noticed the agenda. And so I don't have any additional bills to bring forward at this time, but we are also able to open it up for public comment and board discussion if there is anything that they would like us to look into.
And this is Sharice as well. For legislative items for future meetings, occasionally we'll also introduce ideas about future legislative proposals. At this time, we don't currently have any at the moment, though.
Okay, is there any board discussion about the future legislation? Or any questions for Heather or the staff? Seeing none, can we open for public comment?
We are open for public comment. If you would like to make a comment on future legislative items, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the agenda?
Yes, thank you. And thank you again, Heather. I'd like to move to agenda item 12, regulatory report update, review, and possible action on board regulation packages. Believe Maria Lorenzo is our legislative regulation budget analyst, is going to be presenting this information. Maria, I think you can discuss A through D before we need to start moving one by one.
Dr. Rajo, is it okay if I just provide a report and then take each item individually for vote afterwards?
Not sure what you mean. Say again.
No worries. So the following is a list of board's regulatory packages and their status in the rulemaking process. The first item is the SLIPA supervision requirements. The board approved revisions to the regulatory language on May 13th, 2022. Board staff are working on preparing the required regulatory documents for DCA pre-review. This proposed change will permit SLIPA tele-supervision, require a higher level of supervision during the first 90 days of initial licensure, require SLPs to have experience before supervising a SLIPA, permit the supervisions of 3 support personnel not to exceed 6 at any time, and incorporate by reference a revised supervision form. Our next item is the uniform standards related to substance abusing licensees. The board approved regulatory language on August 13th. Our report notes that the required regulatory documents are with DCA for pre-review. However, I'm happy to announce that on August 10th, they are in the initial departmental review with DCA Legal. Once DCA Legal do their review, it'll go to agency, to the director's office and then to agency. The third item, C, is the RPE direct supervision requirements and telesupervision. The board approved revisions to the regulatory language on October 8th, 2021. The required regulatory documents completed the initial departmental review process on July 22nd, 2022. The board filed the regulatory package with the Office of Administrative Law on July 25th. And the regulatory package was officially noticed on Friday, August 5th, which starts the 45-day public comment period. This proposed change will permit RP telesupervision and establish requirements for the use of telesupervision. Item D is the examination requirements for hearing aid dispensers and dispensing audiologists. The board approved the regulatory language on May 13th, 2022. Board staff are working on preparing the required regulatory documents for the DCA pre-review. This proposed change will update the practical examination process, describe the written examination process, update the practical examination appeal process, and specify the required hearing aid examination for dispensing audiologists to only be the written examination.
Okay, can we stop there and ask for any board discussion? Okay, looks like we don't need public comment at this point. So we can, not seeing any board discussion, move on to item E.
Item E is the CPD requirements for speech language pathologists and audiologists. This regulatory proposal is in the regulation development phase and requires review and approval by the board. And we have a memo and materials to take that item up for vote. So the proposed changes will permit online interactive CPD opportunities, increase the number of self-study hours to half of the required hours, and align hearing aid course content with proposed changes to Hi, Dr. Roger.
Yeah, I'm sorry. I'm
Okay.
just reading
Um,
the summary of changes.
And align hearing aid course contact with proposed changes to the hearing aid dispensers regulation. In light of the discussion and possible action to amend hearing aid CE course content, this proposed regulation was amended and adopted by the board at its May 2022 board meeting. However, DCA legal opined that language adopted by the board violates Business and Profession Code section 17500.1 and must be removed. And that's because the advertising being restricted is neither false advertising nor does it concern to state bar's rules of professional conduct. And so we provided the language to that code and reference in the memo. And so the summary of changes includes that, but we also had to, in preparing the regulatory documents, had to do some other changes. And so I can go through the text and in attachment A to go section by section of what the changes were made since the board last approved the language.
Okay.
So in section 1399-160, we had to remove the definitions for asynchronous and synchronous CPD. And that's because when writing the ISOR for the regulatory package, we had to make sure that when we're using words, we're defining that it's used in other places in regulations. And since our regulations doesn't, in other parts of regulations, didn't reference asynchronous and synchronous, we removed it and instead defined self-study, which is a frequent language used in our regulations. And so what we did was we amended self-study to means a course where the course instruction and licensee participation does not occur simultaneously and requires completing and passing an assessment or examination of the course content at the conclusion of the course instruction. And so we renumber it so it fell right under the CPD as an extension of like that definition. Are there any questions to the changes there?
So self-studies in this case still means, or the description you used, is not a face-to-face live interaction. Is that right?
Yes, it does not, participation does not occur simultaneously.
That's what
That-
simultaneously means.
Yes.
Yeah.
So yes, that was the language used. If you see attachment B, that was the language used in defining asynchronous and asynchronous. And so we incorporated that.
How do you get new language into if you can't use asynchronous and synchronous because they're a little too modern for our regulations? How do you introduce stuff like that?
We would have to change definition anywhere we reference self-study. It would have to have changed to asynchronous.
I see. Okay. Okay,
We
go on.
probably would have need to use synchronous and asynchronous more frequently throughout the regulations on CE and CPD.
Okay.
Another amendment is in, it's a minor change in 1399.160.1 in subsection D. It's not highlighted, but it was for consistency and clarity. When it talks about shall certify, the board had adopted to add the language even though it was already there. So we like to keep as much of the original language there. So that's what the minor change is there. And that's again in section D on page 2 of the text. And then we amended We amended sections 1399.160.3C3 and 1399.160.3E3. And that's to remove the language related to the distribution of marketing materials and then made the changes for consistency. But the major change in those two sections is the distribution of marketing materials, which legal informed us that that it violates the code that we have in the memo.
No other changes?
And then the last change is a minor change. The last section is being added 1399.160.4 to correct a plural. It doesn't look too visible, but we just wanted to note that there. And that's a change that was identified earlier, but in case people wonder why there was a section with like no change. So in B, instead of a licensed audiologist, it's a licensed audiologist without an F.
Okay, sounds like a good change. Okay, is there any board discussion about these changes?
I do have one change requested by legal. Let's see, section 1399.160.3D2. And that is on page 6 of the text on paragraph 2. It has underlined for each license. Also underlined will be shall be earned. That was something that kind of in our editing we missed it, but that it needs to be underlined since it is new text.
Okay. Any further board discussion? Seeing none, I would like to ask for a motion, and language for the motion can be found on page 2 of 2 in the memo.
Dr. Raju, I would like to go ahead and read that if I could, because we do have an as amended in there due to the requested underline.
Okay.
from legal.
Okay.
So the requested motion or suggested motion is to move to approve as amended the proposed regulatory text for sections 1399.160 through 1399.160.4. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. Authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at sections 1399.160 through 1399.160.4 as amended.
Okay, thank you for reading that. Would someone like to make that motion?
I move what she said.
Okay. Do we have a second?
Dr. White, I'll second.
Dr. White, second. Okay. I'd like to open up for public comment.
We are now open for public comment on the motion. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. And our first request for comment comes from Stacy Cooper. I'm going to read what was written, and then I'm going to give you a chance to speak further. Please clarify, is the board considering telesupervision for RPEs and SLPAs? Clarification, I am specifically asking about the supervision of SLPA and RPE teletherapy providers. All right, Stacy, we're sending you a request to unmute your microphone. If you could elaborate further.
Can you hear me?
Yes, go ahead, please.
Okay, yes, that is my question. I was just wondering if that's what it meant when they were talking about future proposals, that they're going to revisit the telesupervision.
So we're not talking about that topic right now. I'm
What
not
was the discussion then about? What are they considering for supervision?
It was, but we moved away from that topic. I don't know how to circle
understand.
back to that.
I don't either, but we didn't get the opportunity. There was no open discussion for that. And that's what I've been here all day for.
Well, we try to be pretty faithful to allowing for public discussion.
Okay, thank you.
But is there a way, Paul, Charisse, to circle back?
Dr. Raja, this is Michael. We can open for public comment at the end of the regulatory report for all items.
Okay, okay, great. So stay with.
Thank you, Michael.
All right.
Is there
That
any
was our
other-
only request for comment. So nothing on the motion.
Okay, so Charisse, I'd like to call the vote for accepting the amendment as, excuse me, the motion as amended.
I apologize, Dr. Raggio. You wanted me to call the roll, correct?
Yes, please.
Okay. Dr. Raggio,
Aye.
Ms. Kaiser,
Aye.
Mr. Borges,
Aye.
Ms. Chang,
Aye.
Ms. Dominguez,
Aye.
Ms. Snow, Ms. Snow,
Aye.
Dr. White.
Aye.
And the motion carries.
Okay, Maria, for the last, well, there's 4 more, I think, 5 more, 5 more. So we probably should go one by one.
Okay, the next 2 don't have action items, and then the last 3 do have action items.
Yeah, so do you want to just, sorry, cover those 2 quickly and then we'll, or not quickly, but cover them and then we'll go more slowly for the last 3.
Okay, so our next item is item F, notice to consumers. The board approved regulatory language on February 25th, 2022. Our report notes that the required regulatory documents are with DCA for preview, but I'm happy to announce that on August 11th, just yesterday, they are with agency for initial departmental review. Once agency complete their review, they will have it sent over to Office of Administrative Law and hopefully maybe get this notice by the end of September, early October. This proposed change will require licensees to provide notice that they are licensed and regulated by this board. The next item is fingerprinting requirements. The board approved regulatory language on May 13th, 2022. Board staff are working on preparing the required regulatory documents for DCA pre-review. This proposed change will require licensees who were initially licensed prior to January 1st, 1999, or for whom an electronic fingerprint record does not exist to be fingerprinted as a condition of renewal. Item H is the CE requirements for hearing aid dispensers and dispensing audiologists. This regulatory proposal is in the regulations development phase. The text requires review and approval by the board, and we have a memo and the text available. From a regulatory perspective, CE requirements are intended to protect California consumers by ensuring that licensees stay current with their skills, knowledge, abilities, and new technology required to dispense hearing aids safely and competently. Through CE, licensees also learn ways to enhance the services they provide to consumers while maintaining ethical practice. The last time changes to the regulations on hearing aid dispensing CE requirements were made in 2016. when the board increased the CE requirements for licensed hearing aid dispensers from 9 hours to 12 per renewal cycle, establish a maximum number of CE hours that may be obtained in related or indirect client care courses, and provided a specified number of CE hours that may be obtained through self-study. In May of 2021, the board reviewed the current CE requirements for hearing aid dispensers and determined that additional revisions to these requirements were merited and delegated the review of these requirements to the Hearing Aid Dispensing Committee. In October 2021, the committee provided board staff guidance on amendments to consider. In 2022, the committee proposed new regulatory amendments and recommended the board approve the regulatory language and initiate the rulemaking process, which included changes to define CE provider distribution of marketing materials during and after courses to be outside the scope of acceptable course content. Similar to the last item we voted that was voted on, DCA found that the language was in violation to Business and Professions Section Code 17500.1, and because the advertising being restricted is neither false advertising nor does it concern the state bar's rules of professional conduct, this language was removed. And so we also provided the language to the code in reference in the memo. And I can go through each of the sections and explain what the Hearing Aid Dispensers Committee, the changes recommended by the Hearing Aid Dispensers Committee. And we also have a discussion question to kind of that the Hearing Aid Dispenser Committee left to the boards to consider.
Okay, why don't you do that?
All right, so in 1399.140, subsection A was amended to provide a cross-reference to exemptions. And then subsection A1 increases the number of in related or indirect client care courses from 3 to 4. And let's see. Subsection C was amended to replace gender terms. On the next page, subsection E is being removed as a statutory authority provided in Business and Professions Code does not permit this exemption. Subsection F and E was amended to make consistent with statutory authority, Business and Profession Code section 2538.54 and 2538.56. Subsections, a new subsection F is being added regarding CE requirements for out-of-state applicants. And this is similar to requirements we have for SLPs and audiologists. G is added regarding CE credit for courses taught by the licensee. And again, this is a requirements similar to SLP and audiologist. And then subsection H is added to regarding CE credit for examination development or administration with limitations of 2 hours for each day of service with a maximum of 4 hours per renewal period. And then lastly, we have subsection I regarding CE courses required as a condition of probation. And it's a similar language we have on the SLP and audiology regulation. Are there any questions with changes to this section?
I have a question, a couple questions.
Okay.
So by striking section E, so going forward, for a person who obtains their license, they are required to get the continuing education requirements done in that first year?
Yes.
Okay. And then section H, for a perfectly selfish question, we're allowing 4 hours for board-sponsored examination development. What about for board members?
I have actually not encountered that. We would have to take a look at that.
Yeah, we can most certainly look into it, but I know the question has actually been brought up just recently, Todd, so that's something we can look into.
Okay. Again, granted, from my position, it seems a little selfish, but you know, we're putting in the time too. That's all I had for that section. Thank you.
Okay, is there any other board discussion? So Maria, could you help us formulate the motion?
Oh, we still have the next two sections.
Oh,
There's
okay,
two more
sorry,
sections being amended.
Long pauses make me think that we're done.
Oh, no worries. Sorry. So the next section being amended is 1399.140.1 regarding course content. In section A, we amended, the Hearing Aid Dispensing Committee amended it so that it can include or to remove the course contact to not focus on equipment, devices, and other products, since now that is going to be included as a course content, as well as changes to the language for grammatical reasons. In paragraph 1, we include as direct client cares courses or course contact on the fitting, programming, troubleshooting of equipment, devices, and other products. And then, let's see, and then in B, we included paragraph 2 where course contact for product-related courses that they can't focus on marketing, launching, or demonstrating the markability of the equipment. And are there any questions on changes here? And I do want to note, actually, in section A, legal has suggested us to make amendments so that it reads, the content of a continuing education courses shall pertain to direct or indirect patient-client care or related to the discipline of hearing aids dispensing, and then strike out patient-client care at the end of that sentence. If there aren't any questions on this section, I will provide a summary to the last section, which is 1399.144, exemptions to CE education. And so here we just aligned this exemptions to what already exists for SLPA and audiologists. It's very fully explained in details our board process on how to get an exemption. And so, yeah, it's just a copy and paste, updating the language there. And if there aren't any questions, we do have a discussion question regarding the allowable numbers for course related to hearing aid devices, if that should be specified.
Is that, what page is that
The
on?
question's on page 3, and the language, if it's a desire of the board, would be added to page 1 of the text under section 1399.140.
Okay, where on page 3?
The question?
Yes.
Page 3 of the memo.
So basically, as it stands right now, because we were discussing limiting the number of hours towards fitting, programming, and troubleshooting, because as it stands now, all it says is no more than 4 hours of continuing education may be credited in related or indirect client care, which means if we left it alone, then that would allow for 8 hours on the fitting of hearing aids, because that is considered direct client care, correct?
That is correct. My understanding, yes, is that if someone was to complete 4 hours in indirect and related, it means that 8 of the remaining 8 hours can be completed in courses related to hearing aids or any other direct client care.
So if we wanted to limit the number of hours that they would could get for that particular type of course, then we need to specify that under Section A of 1399.140.
Sorry, can you repeat that again?
Well, if we're going to actually limit the number of hours, then we need to actually list that under the
Yes. And so one thing I do want to highlight that because of the way the language is written in paragraph 1, technically you can complete 12 hours in direct client care. And since now we're saying hearing aid products are included, that could mean that a licensee can complete 12 hours on products. So that's another way to look at it too.
Right. And we were talking about limiting those hours specifically originally.
Yeah.
Yes.
So that might be another limitation that we want to place a no more than blank hours.
Right. We were talking 4, we were talking 6.
Do you have an opinion, Todd?
Well, my opinion would be to, I mean, initially I thought, well, this kind of says 8. We were talking 4. I kind of in my mind, I sort of landed on 6 because that's half the number of hours that we are required to take a year, since we're required 12. The symmetry of it, I guess, or, it just seemed to make sense to me that since, again, given what the scope of our practice is, I feel like there should be a somewhat reasonably significant number of hours that we can get in regards to that. And 6 just seems to be a nice, clean number.
It seems reasonable to me. Amy, do you have any thoughts about that?
Well, I was just going to ask for clarification. Is that 6 hours about fitting hearing aids in general, or 6 hours of manufacturer specific, product specific training?
Well, it would be 6 hours of essentially what it says under 1399.140.1. Direct client care courses cover current practices of fitting of hearing aids. This may include the content on fitting, programming, and troubleshooting of equipment, devices, or other products of a particular manufacturer or company as it relates to the benefiting of a client's hearing and functional use, etc. So I'm referencing 6 hours essentially on that.
Yeah, I think
fitting, programming, and troubleshooting, essentially.
Yeah, I think that's reasonable. I was just trying to think in my head where, if you went to a training on Relay or something where that would fall in, because it is hearing aid fitting related, but it's not a device specific, manufacturer specific item.
Right. And I think the verbiage of that kind of covers that as well.
Does this kind of go back to the old way we did it, where there was a manufacturer product specific sales kind of?
I honestly don't think so. I think that ship has kind of sailed to a large degree, primarily because the courses are a lot shorter now. You don't see really many 3-hour long courses. They're all in 1 hour bites. So they don't have a lot of time, to focus on that. And, I think that's also a part of the board's then, responsibility as they look at those courses and what is, what is allowable to see, what is going to be covered, and make sure that, those are weeded out. And I think we also take care of it too, because it says specifically that course content focused on marketing, launching, or demonstrating the marketability of equipment, which, et cetera, which I think pretty much covers the timeshare selling aspects of those courses. I think it pretty much precludes that. I'm glad that that was added in, because I think that helps really narrow the focus on what courses we will accept.
Okay, I think you make good arguments. Is there any other discussion about this item?
Would you like to have Maria read the language as proposed for that?
Yes, especially if there's going to be an amendment.
So in addition to the amendment that I had mentioned in 1399.140.1A, the amendment will now include also in 1399.140A, we're going to add a paragraph 3 to say no more than 6 hours of continuing education may be credited on content on the fitting, programming, and troubleshooting of equipment, devices, or other products of a particular manufacturer or company, only as it relates to benefiting a client's hearing and functional use of the equipment, device, or product.
That way we use part of the definition in 1.140.1 to clarify what exactly we're talking about.
Okay. So Maria, do you want to read the motion?
Yeah, actually, I wanted to check in with Karen Halbo, who is our regs counsel, and see what her thoughts were on the amendments we came up.
Karen, I think you're muted.
Thank you. It sounds good to me. I'm writing it down and trying to look at it, and I think that could work. It does what you want it to do.
All right, so then we would have a motion, suggested motion of move to approve as amended the proposed regulatory text for sections 1399.140, 1399.140.1, and 1399.144. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. Authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at sections 1399.140, 1399.140.1, and 1399.144 as amended.
Would somebody like to make that motion as stated?
I move as stated.
This is
Second.
This is Holly. I second.
Okay. I'd like to get public comment at this point regarding this language.
We are now accepting public comment on the motion. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're now going to take a few seconds to see if we have a request for public comment. Seeing no request for public comment, would you like to return to the motion?
Yes, please. If there's no other board discussion, I'd like to call for the vote. Sharice, if you'd help us.
Yep, Dr. Raggio,
Aye.
Ms. Kaiser,
Aye.
Mr. Borges,
Aye.
Ms. Chang,
Oh, I'm sorry, she had to step away, but I think we have a quorum anyway.
you do. Ms. Dominguez,
Aye.
Ms. Snow,
Aye.
Dr. White,
Aye.
motion carried.
Okay, Maria, do you want to continue?
Yes, so we'll skip number item I, and we'll present that at the end as a hand carry item. And I'll jump right into J, which is SLIPA program and academic requirements. This regulatory proposal is in the regulation development phase. This regulatory text requires review and approval by the board, and we have a memo and materials for that. And so at its May 2022 board meeting, the board approved revisions to the SLIPA regulatory package that omitted sections regarding SLIPA program and academic requirements. The DCA legal identified that the board may lack authority to require an additional course for SLIPAs applying for licensure with a bachelor's degree. Because the responsibility of coursework selection is implicitly deferred to the accrediting body, the board identifies in regulation, the board lacks the authority to require additional coursework. And so I provided the code, which reads that a person applying for approval as a speech-language pathology assistant shall have graduated from a speech-language pathology assistant Associates of Art degree program or equivalent course of study approved by the board. A person who has successfully graduated from a board-approved bachelor's degree program in speech-language pathology or communication shall have deemed to have satisfied an equivalent course of study. And so we're looking at that last sentence regarding bachelor students. And so with that, we were ready to present the remaining part of the SLIPA package to the board. And so I can go section by section to discuss this changes since the board last saw these language.
Okay.
Section 1399.170.4. We revised the section title, restructured section B, and changed content to section C, so that it, I believe in attachment B, you can see how the board had approved the language. It had, I think like a list, an item that could have been listed, and so that's what we did. And then here we also maintained some language that was going to be moved to another section. And like I've mentioned in previous meetings, we like to keep original language instead of moving it around. So that took a section away from the regulatory package, which is 1399.170.5. You'll see that in attachment B, what was removed from this package. Section 1399.170.10. These were changes the board approved to correct a typo, as well as increase the clock hour from 70 to 100. And then in 1399.170.1, we changed the clock hour as well to match the previous change, as well as remove the language regarding the course, requiring an additional course for SLIPAs with bachelor's degree. And we also changed, we did a change from 9 months to 36 months to describe full-time work. Are there any questions?
Okay, I don't think there are any questions from the board, but do you have motion language? I'm desperately trying to find those pages.
Yes, it's on page 2 of the memo.
And I can go ahead and read that if you like, Dr. Raju.
I'd really like to find it first. This is not easy. It's not clear. Okay, I don't want to hold up. Go ahead.
Okay. The suggested motion is to move to approve the proposed regulatory text for sections 1399.170.4, 1399.170.10, and 1399.170.11. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. Authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations of sections 1399.170.4, 1399.170.10, and 1399.170 as noted.
Okay, do we have someone who would like to make that motion as stated?
This is Holly. I'd like to make that motion as stated.
This is Gilda. I second.
Is that Gilda?
Yes. Thank you.
Can we open for public comment?
We are now accepting public comment on the motion. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the motion?
Yes, please. If there's no other board discussion, I'd like to ask Therese to call the vote.
Absolutely. Dr. Raju?
Aye.
Ms. Kaiser?
Aye.
Mr. Borges?
Aye.
Ms. Chang?
Aye.
Ms. Dominguez?
Aye.
Ms. Snow?
Aye.
Dr. White?
Aye.
Motion carried.
Okay, I think you wanted to return, Maria, to item I.
Yeah, so item I is the SLIPA application board processing time. Heather Olivares, my colleague, will actually present the item. And this is a hand carry item,
Which is available on the board's website.
Okay, good afternoon, everybody. Heather Olivares, Legislation and Regulation Analyst. For agenda item 12I, this is regarding the SLIPA application and board processing times. At the October 2021 board meeting, board staff recommended to the board to repeal the regulatory provisions establishing processing times for applications through the Section 100 regulatory process. As part of that meeting, the board adopted 16 CCR sections 1399.113 and 1399.151.1 to implement Government Code Section 15376 with respect to permit processing times. This government code was part of the Permit Reform Act of 1981, which required state agencies to adopt regulations regarding their procedures for considering and issuing permits. However, that act has since been repealed by Assembly Bill 1757. Therefore, specifying processing times in regulation is no longer required by law. However, due to an issue with the authority used to establish the processing times in regulation, The board was unable to repeal these sections through the abbreviated Section 100 regulatory process, and these changes must go through the formal regulatory process. This is because the amendments made in 2015 were not based on Government Code Section 15376, but on board authority that is still in existence related to the board's public protection mandate. Board staff is proposing this regulatory action to include the repeal of processing times that were unable to be repealed via the Section 100 process, including relevant cross-references, as well as making changes to the SIPA application that is presently a form incorporated by reference in the current regulations. These changes are necessary to streamline the board's operations as part of the business modernization project. By placing the information required in the application form in regulatory text, staff can make changes to the formatting of the application without needing regulatory approval. Also, the criminal conviction question is removed based on Business and Professions Code Section 480, which became effective in 2020. The Department of Consumer Affairs Legal Affairs Division is working with staff to clarify language on how applicants submit educational transcripts and information about fieldwork and what procedure is followed if an applicant is unable to live scan. The board can approve the proposed language and instruct staff to proceed to public notice and comment after making any additional changes to the regulatory text in section 1399.170.13 in accordance with the board's policy directives needed to address the concerns raised by DCA Legal. If there are any changes from the version of the text in attachment 1, the text would come back for board approval at a future meeting prior to final submittal to the Office of Administrative Law. So following this memo are the actual changes in the regulatory text. The first one is a complete repeal of section 1399.113 regarding hearing aid dispenser processing times. And then following that is a full repeal of section 1399.151.1 regarding the processing times for the SLP license, an audiology license and aid registrations and continuing professional development approvals, and the SLIPA applications. And the reason we're proposing to repeal all these processing times is because they're outdated, and the business modernization project is going to further streamline our process, so we'll actually be able to approve applications faster than we're required to in regulation right now. And then the next section is 1399.160.6. We're just removing a cross-reference to section 1399.151.1 that is going to be repealed. And then in section 1399.170.13, this is the SLIPA application. You'll see struck through, we currently have forms that are incorporated by reference, and those forms are outdated. So we're going to be repealing those forms and then adding from the current forms that we use that we included as attachments. We're going to be adding all the information that is included in the forms in text format. And by doing that, it'll allow us to follow the regulations when we're doing our business modernization process. It'll allow us to ask for all this information without specifying a certain format that it's going to be presented in. So it just gives us more ability as our forms change in the format, as long as we're not asking for additional information than what's in regulation, we'll be able to change the formatting. So does anyone have any questions about this proposal?
Doesn't appear so. So can we, someone would like to read the suggested motion language?
I can do that for everyone. The suggested motion is to move to approve the proposed regulatory text for sections 1399.113, 1399.151.1, 1399.160.6, and 1399.170.13. Direct staff to make any additional changes to section 1388.170.13 in accordance with the board's policy directives that are needed to address DCA legal's concerns, and then submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. Authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at sections 1399.113, 1399.151.1, 1399.160.6, and 1399.170.13 as noticed.
Okay, would anyone like to make that motion as stated?
I move as stated.
I second.
Can we open for public comment?
We are now accepting public comment on the motion. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the motion?
Yes, please. Okay, if there isn't any further board discussion, would you call the, oh, Debbie, did you want to? Is your hand up, Debbie?
Hold on, she got sent out of the panelist. Apology. Debbie, do we have you back in the panelist?
Yes, can you hear me now? My internet went out for about 5 minutes. I just got back in. Could someone just give me a really brief update of what I missed?
Absolutely. So the materials are recommending adoption of the language as revised and to approve the language regarding removal of the processing time requirements and the adoption of the changes to the SLIPA application to a narrative format instead of an outdated form that gets put into regulations in the specific format. So it essentially takes the the current SLIPA application and puts that into narrative form inside of the regulation.
Members know this is Michael Knoch, your legal counsel. Because you did not hear the entire discussion, I would advise you to abstain on this motion.
Okay, thank you.
My apologies.
No, I thank you for clarifying.
Okay, Sharice, can we call the vote?
Absolutely. Dr. Raju,
Aye.
Ms. Kaiser,
Aye.
Mr. Borges,
Aye.
Ms. Chang,
Aye.
Ms. Dominguez,
Aye.
Ms. Snow,
Abstain?
Thanks. And Dr. White?
Aye.
And the motion carried.
Okay, thank you, Maria, for the regulatory report. I'd like to move to agenda item 13, which is future agenda items, and ask if there's any board staff comment they want to make before there's any discussion by the board.
Excuse me, Dr. Rajo, Paul Sanchez here. I just wanted to go back. I think we said we were going to open up public comment again for the question that we had regarding the other.
Yes, and that is my intention, but I'll do that when we're going to ask the moderator to open in just a moment. Would that be all right?
Yes.
So for
Yeah, sorry.
my apologies. For clarification, we're opening on future agenda items.
Well, I was waiting for if the board staff wanted to make any comments at this point, and if not, was there any board discussion? And then I was going to do that. So if we don't have any board comment or, staff comment or board discussion, is that the case? Nobody has any comments at this point about future agenda items? Seeing none, it looks like we can open for public comment, and I would like to encourage the individual who attempted to speak earlier to utilize this time to make her comments.
All right, we are open for future agenda items. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. And we have a request from Stacy Krupper. Hold on just a moment. We're sending you a request to unmute your microphone.
And just to clarify, this is Michael. We're open for public comment on the regulatory report as well, and we can do those together.
Okay.
Okay. Thank you for opening it back up. As far as the regulatory report number 12A, and then also I think it's C, I wanted to just get clarification. Does that mean that the board is having a possible action in the future regarding SLPA and RPE teletherapy supervision? Can they be supervised via teletherapy?
This is Sharice. Dr. Roger, if you're okay, I would like to go ahead and take this one.
If you would, please.
Thank you.
Absolutely. So currently 12A for the SLPA supervision requirements, the board has already taken action, and that regulatory text is approved by the board and is now going through the regulatory process. Before it becomes law or adopted as regulations, it has to go through a formal rulemaking process. As it currently stands, it's in the regulatory package preparatory stage. So that second little section there on the agenda item 12 in the material. It'll next go to DCA for pre-review, departmental review, and then to the Office of Administrative Law for public comment. When that is noticed with the Office of Administrative Law, that really kicks off the public comment stage and really gets us closer to when it can become official law. Once that package is finalized, it goes through a final review and submission to the Office of Administrative Law. The final step is the Office of Administrative Law making sure that we have followed the Administrative Procedures Act and that all laws and public comment were taken and we've met all official deadlines. And then once that decision, if it's approved, that regulation becomes effective at a specified date or the next quarter, whichever is specified in the regulation, and then it becomes official law. So the board has approved text to allow SLPA telesupervision and the other items displayed on 12A in the memo on page 1. And when it comes to the RPE, or the required professional experience, that package is at the public comment stage. So the board approved text, it went through the pre-review stage and initial departmental review, and was noticed with the Office of Administrative Law on Friday, August 5th, and that started the 45-day public comment period. Now, the board is accepting public comment and support or not. Any public comments can be submitted to the board. You can go to the board's website under the laws and regulations, which is under the licensee tab, and in a couple other places, and it'll show the proposed text, the initial statement of reasons, and it also tells you what date the public comment period ends, which I believe is September 20th of 2022, and those comments can be submitted via writing or email. And then the board considers those and follows through with the rest of this, where we take the public comment, we make answers, and then it goes through that final review process. And then again, once it gets to that final OAL decision, then it would become law.
Great. Thank you so much for explaining all of that.
You're welcome. I know it's a lot of steps and stages, so.
That's okay. That's helps to know. Thank you.
You're welcome.
Are there any other questions about the regulatory information?
Miss Snow and Miss Oliveris have their hands up.
I see you.
I'm sorry, I was trying to lower mine. It's a mistake.
Okay, Heather?
This is Heather Olivares. I just wanted to add on to what Charisse explained on our website under Board Activity tab, the laws and regulations. We have a lot of information on there about what legislation we're currently looking at and what regs are currently in process. But I just wanted to point out at the very bottom of that page, there's a link that says if you want to sign up to receive updates, you can sign up for the board's legislation and regulation changes email notification list. And that's the best way to stay updated on what we're doing, because every time a regulation goes for public comment, we're sending out a notice through that process with information on how you can submit your comments to us.
Okay, thank you.
你把水把它用了。
Karen, we can hear you.
Sorry.
There are no other requests, Madam Chair.
No further public comment?
No further comments, Madam Chair.
Okay. So at this point, the board is going to go into closed session, but I'm wondering if we couldn't take about a 10-minute break before we do that. But the moderator is also going to leave, so I don't know, or are you leaving?
I am here until you need me to go. So I am not leaving yet.
Okay, so what do you think about taking a 10-minute break before we start our closed session?
Good idea.
And Madam Chair, this is Michael. Let's also just announce, and I can do that we will be adjourning from closed session. There will be no more open session. So the public portion of the meeting has ended now with the break.
Okay.
This is Paul. Thank you all. Have a great weekend.
Thank you.
Yes, Amy. So thank you all, and have a great weekend. I look forward to seeing you next time.